Everyone. My name is Fadi Zahtari. I am Research Associate at Center for Islamic and Global Affairs at Sabahattin Zaim University. Welcome at day 5, and this is session 8, which is entitled Examining the Dangerous Tactics of the War in Terror. This session will be moderated by Professor Nagihan Haliloğlu. She is a lecturer in comparative literature at Ibn Haldun University. And she published articles on multiculturalism, modernism, travel writing, and Turkish literature. I am very happy to see you, Professor Nagihan Haliloğlu. She is also my professor at Ibn Haldun University. Yes, the floor is yours.
Thank you very much. I'm very, very excited to be chairing this panel, which is full of practitioners. So as an academic, I feel humbled to be in the company of people who are kind of fighting this kind of stuff on the ground. We will start with Gary Sowards, and I've been told to keep the bios short. And I will just share one line from the biography he shared with us. Since 2008, he has served as a defense attorney in capital military commissions at the United States Naval Base Guantanamo Bay, Cuba. And his title will be Rendition and Privatization of Security. So please, Mr. Sowards, the floor is yours.
Thank you, Nagihan. Assalamu alaikum wa rahmatullahi wa barakatuh.
Alaikum salam.
And good morning, ladies and gentlemen, brothers and sisters. Also, good afternoon and good evening, wherever you may be. I want to also thank Dr. Sami Al-Arian and the Center for Islam and Global Affairs for inviting me to this and having an opportunity to participate. I've been able to see some of the other sessions, and it's really very fascinating and interesting stuff, and I think very supportive of what we do. And thank you for that acknowledgement of our work, Nagihan. Shortly after the US invasion of Iraq in 2003, I heard a story from my sister-in-law in California, where she and her husband have friends whose son at the time, this is in 2003, was a mechanic on helicopters at an air base in Tucson, Arizona. And shortly after the invasion, they said to him, they said to the parents, well, does this mean your son either is or will soon be in Iraq, working on all of those helicopters we're seeing in the news? And they said, no, not at all. He's going to spend whatever will be the war, most likely in Arizona, and the maintenance of the helicopters will be performed by mechanics who are employed by private contractors and paid $90 an hour to do this work. And it turned out after that these $90 an hour mechanics were part of the US spending during, actually during just the first 10-year period after the 2001 invasion of Afghanistan and continuing the 2003 invasion of Iraq. Totaled over $117 billion to pay for private contractor services. And actually from the outset of the US invasion in Afghanistan, the military's campaigns in both Afghanistan and in Iraq, and of course a broader war on terror, the military and the private sector have been extensively involved with one another, with private contractors doing long-range reconnaissance and direct action, and airline companies transporting prisoners as part of the rendition and torture program conducted by the CIA. As Nagihan mentioned, I am a member of a defense team working with other defense teams to help Muslim prisoners who are facing possible death sentences in the military commissions at Guantanamo Bay. We daily deal with the impact of what the conference organizers have correctly termed the dangerous tactics on the war on terrorism, including rendition, as well as torture itself, and the privatization, so-called, of security. I want to posit that it's instructive to consider these issues from the perspective of our clients, because many of the great and very justifiable concerns about the egregious injustices of the United States and Allied forces' war on terror has been the concern with its impact on what we call completely innocent people, people who were, in the phrase, in the wrong place and at the wrong time when they were arrested for a variety of reasons and disappeared into US-controlled black sites. These people are usually known by descriptors such as, I can't figure it out, he has nothing to do with extreme Islam. Or this young person or older person would have nothing to do with jihad, using its term in the term of its most restrictive meaning to indicate violent struggle. But it's the case, and I think it's heartening to see an increased appreciation of the fact that the traps and abuses that are set for one actually ensnare all. And so our concentration on the evils of rendition and torture note that they are the same for people, irrespective of whether the government claims that it has, or perhaps it even does have, some actionable information suggesting that they may have been involved in violent acts. But at this point, there is a presumption of innocence that attaches to them. And at least under the system that we are trying to enforce in Guantanamo, they cannot be subject to punishment until they are convicted. And so even if torture and other forms of cruel, inhuman, and degrading treatment were permissible, which of course they're not, there is no punishment that may be inflicted upon an individual who is captured and charged, but not convicted of a crime. And so I think as we talk about these dangerous tactics and the tolerance of dangerous tactics, we look at Western society, but I think it is applicable to many societies that have a tolerance for outrage and a growing capacity for indifference that actually correlates to skin color and religion of the victim of the abuse. And when we add to that, that particular dynamic, a perceived existential threat. And in the United States, as you know, the war on terror is justified by the notion that we are combating a foe that hates us for our values and wishes to eradicate those values. When we pair this sort of capacity for indifference and tolerance to outrage based on religion and based on the skin tone of the victim, and we pair all of those, we have conditions for government abdication of its responsibility to protect civil and human rights. And the manipulation and exploitation of fear, particularly by politicians and members of private industry, are part of a preconditioning of populations and institutions' willingness to cede authority and large amounts of resources to individuals who plausibly offer protection from harm. And there are three particular aspects that we have become aware of, two of them directly affecting our clients, and I think a third which bears upon them, but also clearly affects the greater Islamic community, the Ummah worldwide, has a threat for that. And the first is the government's abdication of responsibility and the potentially expansive private sector irrigation of government function that is invited by increasing reliance on privatized security, taking forms of rendition and other clandestine or at least out of the public operations. Second is the government's protection of contractors against legal liability through the invocation of national security measures such as classifying information or invoking state secret acts to shield their, shield information regarding their activities and the harm to other individuals. And then third is the degree to which the private sector government collusion is actually scaling up the use of security measures for the purpose of oppressing larger populations, and that this practice is increasingly becoming a feature of standard commerce. As to the first concern about the government's abdication of responsibility and expansive private sector filling the vacuum of the government work, it's important to note, I think, first that it's a slight misnomer to refer to privatization of security measures. What we really have are surrogates or proxies who make a lot of money doing the government's bidding, while at the same time helping to absolve government actors and in turn being absolved themselves of the abuses that stem from that. And what we see particularly, I think, is illustrated by our cases in Guantanamo, is the degree to which the private corporate functions, so-called private corporate functions, are intertwined with and shielded by sovereign identity of the state. In the United States, there's actually a fairly long-standing model for this kind of relationship, dating back at least to the time of the use of the Pinkerton Detective Agency, which would align with military and local police forces in the suppression of labor organizing and other progressive activities. What is increasingly being seen is a shift in alignment that the private security, the private forces are actually taking over whole cloth, large areas of operation. Currently, the United States, which will probably not surprise anyone, is the world's largest consumer of private military and security services. And this has more recently its beginnings with the US involvement in what were termed peacekeeping missions in the Balkans, where for the first time private contractors began to equal the number of the military personnel involved. And this was in part an outgrowth of the reduction of logistical capabilities and caps on troop sizes that resulted from the end of the Cold War. But then shortly after that, the degree of reliance on the private military and security companies, the so-called PMSCs, by the United States government really mushroomed during the War on Terror. And so we see that in Afghanistan, the first war in which the number of private contractors actually exceeded the number of military personnel involved. The PMSCs allow the government to outsource a variety of tasks and functions, many of them mundane, but they also afford them cover for sensitive or potentially unflattering activities, which we'll talk about more in a moment. But these can include things that appear to be legitimate, but things for which the government wants to keep a distance, such as the construction of detention facilities in so-called host countries. And the question now, and during with these operations, is how much governmental authority and power these companies are allowed to wield without actual supervision or control by the government agencies. And I think one sort of illustrative case study, at least it piqued my interest in just tabloid-like gossip. So I thought it was worth talking about and using as an illustration of some of these factors. Is that despite the negative publicity and largely negative reaction by Congress and the public to the description and documented evidence of torture and abuse that occurred in the CIA rendition and torture program and was documented in the United States Senate Select Committee on Intelligence report on that program, that within the first year of the Trump administration, there were serious proposals made to fund what was called a private rendition and spy network. So returning to a sort of full throttle use of private rendition companies and functions to target and arrest and render so-called suspected terrorists. And the plan, even more somewhat unimaginable, which was proposed by Eric Prince, the billionaire owner of what used to be called Blackwater security firm, now called, I think it's Academy, after a number of scandals and tragedies tied to the company. But this plan was put forward only after an earlier proposal, which he had made to actually privatize the war in Afghanistan. The entire United States war effort would go private and would be paid for by the exploitation of natural resources in Afghanistan, including rare metals. But when that didn't materialize, he shifted focus to this plan for a global private spy network, which had as its appeal to the people who were interested in it, including Trump administration officials and then CIA Director Mike Pompeo, was that it would be a way to circumvent any U.S. intelligence agencies and provide these covert services directly to Pompeo and President Trump. And that's actually one of the sort of hallmarks of a lot of these programs, particularly in our case with our clients. The purposes for which they were set up was not a matter of government efficiency, either in terms of cost or even carrying out a mission, but in large part to be able to shield the activity and remove it from any constraints of what would be regarded as sort of meddlesome career security people or members of the administration who might ask questions about the legality of what these operations were doing. And the sort of model or the pattern that these programs follow is to diffuse responsibility through the impression of delegating work under the rubric or the rationale that it's more efficient and the contractors themselves are more skilled in carrying it out. As one commentator declared the scenario and the operation of these sorts of models was to say, quote, so the government wouldn't be involved, except that the company would say that it was acting with the direction and control from proper government authority, except the company wouldn't be involved either. And back in the 1970s, for those members of your audience who may be a little older, this is what the Nixon administration pioneered and developed as the concept of deniability, that you could, excuse me, who's he there? Whoops, what happened? Did you go away or did I go away? Sorry. The concept is the concept of deniability, that what someone else was doing in another compartmented section of the bureau or the agency, we didn't have to know about. We just knew what their marching orders were, and they would take care of it. So, in addition to targeting supposed terrorists for capture and rendition, this Prince proposal also was a perfect scheme by which the principals could stream untold sums of money directly to their pockets without anybody being aware of what was going on. And what is amazing, and I just want to take a couple of brief moments to review, is the amazing cast of characters that were involved in this and illustrate the sort of incestuous interlocking relationships that drive these industries and actually persist for long after their initial outrages or their work come to the public light. So Blackwater is headed up, and since renamed, was headed up by Eric Prince, and of course is a private security firm whose agents killed 14 civilians and wounded 17 others in Nisour Square in Baghdad in 2007. Among the former military people who were scheming with Prince and developing this plan was Oliver North, a throwback to the Iran-Contra scandal, but who is still active after all these years. Prince, in turn, was also joined by a longtime associate, fellow by the name of John McGuire, who is also a CIA veteran and a former member of the Trump transition team, who was then associated with another contractor intelligence security firm called a Mentor Group. And the executive vice president of a Mentor was a fellow by the name of Frank Gallagher, who, coming full circle, was also a Blackwater veteran and a former agent in charge of the security detail for Paul Bremer during the early days of the US occupation of Baghdad. And meanwhile, the CEO of a Mentor was spending his time fighting a 10-count indictment for running a years-long scam to coerce $2.3 million from a wealthy businessman for what the prosecutors called non-existent, off-the-books CIA operations. Near the end of the Trump term, a Mentor had collapsed under disarray and the scandal. But Trump, nevertheless, had a consolation prize for his Blackwater colleagues in granting pardons to the Blackwater security guards who were responsible for the carnage in Nizuer Square. But even without this outrageous action by the outgoing president, the lack of accountability and the traditional restraints on quasi-government actions were known for the longest time to give rise to the excesses of arrogance and violence that make Blackwater, other companies like Tiger Swan, and no doubt would have made a Mentor hated around the world.
Gary, 2 more minutes if you can.
Okay, I can do it.
Perfect.
All of this plays out in our cases, and then we'll take some maybe time for questions and answers. Plays out in our cases in the protection of government contractors who were paid $81 million and whom the government was prepared to pay an additional $100 million for a series of what may be known to folks attending the conference, but were outrageous acts of unmitigated torture, including anal rape, mock executions, slamming of heads against walls, forced nudity, sleep deprivation, denial of food, constant noise, and forced stressed positions. There were also types of torture that were directed directly at Islam and torturing Muslims as Muslims, including forced nudity in the presence of women, denial of ability to purify themselves or even know what the prayer times were or the direction of the Kaaba. The Bush administration, after these events came to light, adopted a series of classification restrictions and devices that we continually fight against in an effort to actually close off and classify the memories and recollections of the victims who were subjected to this activity. So they've actually said that because these individuals were tortured in the CIA torture program, they are privy to classified information that they can't repeat. And someone said that's as if we said the victims of Hiroshima and Nagasaki were privy to the classified information of the United States Manhattan Project. They have developed a number of Orwellian devices, including the use of the mosaic theory that prevents us even from making use of open source, widely reported information, if to do so in the context of our litigation would give away or appear to confirm classified information. And in the bargain, they have indemnified the chief torturers, Drs. Mitchell and Jessen, and also given them a war chest of $5 million for their defense in any criminal or civil proceedings. And then finally, the last sort of warning I just want to note is corporations, the extension of this activity of legitimate corporations worldwide into security and suppression methods, such as in, I guess it's also not Blackwater, I'm sorry, Amazon, sort of like the consumer version of Blackwater. But in Xinjiang, northwestern China, the example of the Uyghurs, who are the victims, the endpoint victims of these massive artificial intelligence and facial recognition programs, which are at the basis of forced relocation and forced re-education. And the point here is to note that the greatest evil of torture is the disruption of the identity. And that is exactly what the programs aimed at the Uyghurs and Muslim minorities in China are aimed at doing. But they don't have the same, I guess, appeal or an intuitive revulsion that physical torture does. And instead, our concerns are more with whether there are forced labor that are somehow artificially affecting the price of cotton. Thank you very much.
Thank you very much, Gary. I've got lots of questions and personal kind of grievances as well, but I thought that we might leave the questions at the very end, so the listeners, the audience, can have time to formulate them. And I should have said this before as housekeeping. So we've got each speaker has got 20 to 22 minutes, and then after we finish, we'll go on to the questions, inshallah. Right, move on to James Connell, who is also in the field, so to speak, a human rights, a criminal defense and civilian death penalty defense attorney in the Guantanamo Bay Military Commission. And he will be talking to us about torture, assassination and drones. And yeah, the floor is yours, please.
Thank you so much. I'm going to take a moment and try to share my screen.
Yeah, we see it. It's good.
Great. Yes, my name is James Connell. I'm one of Mr. Sowards and Ms. LeBeouf's colleagues in the struggle in Guantanamo Bay against the continuing oppression of Muslim men there, as well as the seepage of the policies created at Guantanamo Bay and in places like Abu Ghraib into the larger society, whether that is into the law of the United States or whether enforced by the United States against other countries. I would like to echo the thanks to Dr. Al-Arian and the many people who have worked to bring this conference into existence. Although we are practitioners, the work of academics is critical to what those of us who don't have academic credentials and struggle out in the field are doing. I know that myself and my colleagues constantly consult the literature to find out the most recent thinking, to change the frames of what's happening, to examine the assumptions that we ourselves are prone to fall into, whether those be assumptions of Islamophobia or of government power or other frames that we operate in. So we in the field owe a giant debt to academics, and even if it's not always recognized, it needs to be. And finally, I feel that I would be remiss from saying that, like my colleagues, I came to this work from the fight against the death penalty. And my home practice state of Virginia in the United States has just become the most recent state to abolish the death penalty, and is the first state in the south of the United States, traditionally the area with the most problematic, racist, and anachronistic structures. And I hope that that forms a basis for other people addressing the problems of the United States past and moving forward on our issues, especially of racism toward African Americans. I do have to give you a little disclaimer because in one way, I'm one of those contractors that Mr. Sowards talked about. I work as a lawyer with the contract to the United States on Guantanamo issues. So Guantanamo the United States spends billions setting up these torture programs and prosecuting people at Guantanamo Bay. And then it spends a much smaller amount of money paying me to defend them, which is a very American approach to the problem. But I just have to let people know that I'm speaking only for myself, not on behalf of the United States, the Department of Defense, the Military Commissions Defense Organization, or anyone else, and that nothing in this presentation is based on or confirms or denies classified information. So let's move forward and talk about the first topic of this is torture. And the torture has been an issue that was discussed a lot at certain times. At sometimes it's been a political issue, at sometimes it's been ignored as a political issue. And the most high-profile example of the United States decision in the early 2000s to use torture as an instrument of state policy and state violence in the so-called War on Terror is the CIA RDI, or Rendition, Detention, and Interrogation Program. What most people know, and that includes very knowledgeable academics as well as ordinary people on the street, what most people know about the torture program comes primarily from a series of articles done on a sort of piecemeal basis in the 2000s, and then the release of the Senate Select Committee on Intelligence Torture Report in December of 2014. Under that narrative, painted by the torture report and supported by media reports, the CIA arbitrarily detained 119 men and subjected 39 of those to a particular form of torture called enhanced interrogation techniques. This narrative is true, but it's incomplete. And one of the things that we have been struggling with at Guantanamo is to dig deeper into that narrative and find out more about what actually happened. Because some of the watchers, listeners may have even read the torture report, but many, I'm sure, if they're interested in this area, have read about it. And it's important to remember that what was publicly released was only the executive summary. It was not actually the torture report itself, which runs many thousands of pages long. Instead, it was an executive summary that is highly redacted, redactions applied by the CIA under as original classification authority, and thus a curated story of what happened came out. Of course, the story itself has its own perspective, which has to be taken into account as well. It's one of the great contributions of academics to this process is reminding us of the biases that we culturally or epistemologically bring to our work and encouraging us to look beyond those frames and figure out more. So there are a few points that I'd like to bring to your attention about the torture program. Some of them with the larger narrative and some coming out of the work that we've been doing at Guantanamo. The first is that a focus on the rendition, detention, interrogation program is a massive undercounting of the human cost of the decision to use torture and other cruel, inhuman, and degrading treatment. The 119 prisoners who are mentioned in the torture report don't count many people at other detention facilities like Bagram or Abu Ghraib, people detained for the United States by other countries, and perhaps other people outside the 119 that we don't even know about. One of the most interesting analysis, and I look forward to an academic analysis, is how the CIA successfully framed a debate, the debate over this entire arbitrary detention and abuse program, as limited really to the question of whether enhanced interrogation techniques are torture or not. If in the United States, at least on the more liberal side of this debate, the claim is enhanced interrogation techniques, the strategies outlined by the government are torture, and on the other side, no, they're not torture. But really, that framing of the debate ignores an enormous amount of important information. One of those, of course, is that cruel, inhuman, and degrading treatment is prohibited under international and American law, as well as torture. It also excludes a holistic analysis. There are some, my own client, Amar al-Baluchi, has publicly released statements after a long declassification process about how ridiculous it is to talk about having a single whether a single technique is torture or not, when no single technique is ever applied, that a person is naked and starving and on the edge of dying of thirst and prevented from practicing their religion and physically abused and mentally abused all at the same time. So taking this as a single event, and whether it's torture or not, is really a success of the torture narrative because it isolates things so much. The Omar al-Baluchi, my own client, is one of the 14 men who was transferred in September 6-ish, 2006, from a black site to Guantanamo. He happens to be one of the most damaged men and also one of the most in need of torture, treatment, or rehabilitation. And as part of recognizing his suffering and seeking to both oppose the death penalty and the punishments which the United States government seeks to impose on him, and to seek some measure of justice, we have been, in 2019, the last 3 months of 2019 and the first several months of 2020, before the global COVID pandemic hit, we've been calling witnesses with respect to the torture program in the military commissions in Guantanamo. And we've learned two very important and interesting things as a result of that. The one thing that is not known at all is how much, it's fairly well known that in the torture program, the United States government chose to take a program which trained military and civilians to resist exploitation and reverse engineer that to exploit men. On the left here is a picture of Zain Hussein, also known as Abu Zubaydah, that he drew of what standing sleep deprivation looks like. Standing sleep deprivation is a pretty banal term for the pain that we see Mr. Hussein experiencing there. But there was another reverse engineering which took place, which is a reverse engineering of the literature which has been developed by academics and practitioners on trauma, particular intentionally inflicted trauma like torture, and the treatments and rehabilitation which are available for that. There's one example, just one little clip of thousands of pages of transcript that I've added to this slide. And Dr. Mitchell, one of the framers and implementers of the torture program, testified over the course of 2 weeks at Guantanamo, and he talked about some of the recommendations that he made. He talked about the value that he found in Dr. Mario Michelincer's books on learned helplessness, and then there was a time immediately after Dr. Mitchell and his partner, Dr. Jessen, had concluded with the first phase of the torture of Mr. Hussein, who's shown there, his drawing is shown there. And someone else, we don't know who, wrote to Dr. Mitchell, emailed Dr. Mitchell and said, wow, it seems like you got a lot of information out of that person. What would you recommend that I read? And one of the most shocking things, what Dr. Mitchell recommended that his interlocutor read is a book by perhaps the world expert on torture, trauma, and its treatment, Dr. Metin Başoğlu. And he recommended this. So the testimony on the right-hand side of the screen is a transcript of the recommendation of Dr. Mitchell to another person who wanted to get into the same business Dr. Mitchell was in, that the interlocutor read Torture and Its Consequences, edited by Dr. Başoğlu. And it was just astonishing to me that incredible work done by incredible academics and practitioners who are working to decrease suffering was reverse engineered to maximize and increase suffering. There was a focus by Dr. Mitchell and others on the same factors that Dr. Başoğlu talks about with both torture and earthquakes, their unpredictability and their uncontrollability. In Mr. al-Baluchi's case, this has resulted in the application of of techniques based on these theories has resulted in brain damage, which is well documented by both the MRI and volumetric analysis. But the main purpose of the CIA and its other people involved in this was to create an exploitable state. And to do that, they themselves relied on the work of Dr. Antonio Damasio regarding on how decisions get made, because their goal, torture doesn't work like it does on movies, where someone stands with a gun and pistol whips a prisoner and asks them where the bomb is. Instead, the goal is to create an exploitable state of mind, that is to change the personality of a person so that they are willing to cooperate both then and later. The other main thing that has come out of the work at Guantanamo is that although the principal narrative is as the Central Intelligence Agency as the primary implementer and beneficiary of the torture program, in fact, it was interagency throughout the United States government. We have had testimony from numerous FBI agents who have described the intelligence loops, or the information loops which took place. And the FBI has been largely immune from criticism, and the CIA has taken most of it. But instead, in actual fact, there was a process by which the CIA would let it be known that they were open for questions to be sent. People from other elements of the government, FBI, and some other elements of the government would send cables to the CIA to CIA headquarters, who would send them out to people in the field who would conduct the torture, what they call service the requirements, and then relay that information back to CIA headquarters, who passed it throughout the intelligence community, the massive intelligence community in the United States. And then agencies like the FBI, the domestic law enforcement agencies in the United States, would act on that by arresting people, by obtaining warrants, and all the while obscuring the source of the information that they had obtained as a second party to torture. The other point that I want to cover is the changes which have taken place since that time. After 2006, or in 2005 and 2006, the law changed in the United States under a bill sponsored by Senator McCain, who had himself been tortured in the American-Vietnamese War. And the CIA began to push back on what they considered their criminal and civil liability. President Bush, 4 presidents ago now, greatly diminished the CIA footprint in their ability to detain, and President Obama issued an executive order which purported to eliminate that CIA detention program. But there was a transition from there to a strategy based on assassination and airstrikes, supplemented by special forces. We often call this drones, and many of the weapons which are used are unmanned aerial vehicles, but there are traditional airstrikes, of course, as well as special forces on the ground. There's enormous sort of interagency rivalry, and at different times, the CIA and the DoD have taken the lead on this program. But there was a massive swelling. This data chart shows civilians killed in airstrikes in Pakistan between 2005 and ultimately 2015, when the United States stopped airstrikes in Pakistan, swelling. And just so you know, on this, the bright red are children. Of course, the United States and many other countries are involved in ongoing hostilities in a number of countries, including Afghanistan, Syria, and Iraq. This chart, based on U.S. government data sets compiled by Air Wars, shows the number of confirmed civilian deaths from airstrikes in Syria and Iraq over the past 10 years. And some of those are targeted at individuals. Some of them are signature strikes where they target a group of people. The most famous recent assassination was of Qasem Soleimani, of course, who was assassinated in Baghdad on 3 January 2020, an Iranian leader who was targeted in a third country. That assassination, like others, has justified under United States law as self-defense against an imminent threat, although the nature of any imminent threat, as opposed to some sort of larger strategic threat, is essentially never articulated, and really shows how far the justifications for killing in the United States have been stretched. Of course, there are other zones. More recently, Somalia and Yemen have been the focus of United States airstrikes, including the massive uptick in Somalia in civilian deaths under President Trump, and especially in 2017, large number of civilian killings in Yemen. These are all based on official United States data. Interestingly, there has been something of a COVID effect with a decrease in targeted killings over 2020. Last thing that I want to say is that we don't really know yet what President Biden is going to be doing. He has acknowledged ordering airstrikes in Syria, but in early March, he ordered a policy change. The policy change doesn't ban drone strikes or anything like that, but outside of Syria, Afghanistan, and Iraq, it takes control of drone strikes out of the hands of the agencies, the DOD or CIA or whoever is handling it. Requires White House approval for those. The Biden administration claims that there is a policy review going on. No one really knows what's going to come out of that. Obviously, COVID has attracted most of the attention of the administration. And the very last thing I want to say is that if these are topics that interest you and you're interested in, like, wow, I didn't know all this stuff was going on at Guantanamo, I highly recommend the Twitter account Gitmo Watch, spelled with an I, GITMOWATCH, which live blogs hearings at the Guantanamo military commissions and assembles ongoing information about changes in U.S. foreign policy, especially relating to torture and other instruments of state violence. Thank you.
Thank you very much, James, for this very kind of sobering reminder of that this is an ongoing issue, and it's not, it's not in the past. We will continue with Denise LeBeouf, who has been the director of the American Civil Liberties Union John Adams Project since 2008, participating in the defense of the capitally charged Guantanamo detainees in military commission. And her title will be The Black Hole of Guantanamo. Please, Denise.
Good morning. Salam alaikum, brothers and sisters. Bismillah. I really want to start by saying how profoundly grateful I am to Professor Dr. Al-Arian and to his colleagues, all of you at CIGA. I feel very lucky that I got to visit you, some of you, at CIGA in, I believe it was 2019, in the company of my my colleague, Asim Qureshi, my colleague and friend. And I can visualize the place where, inshallah, we will all be together again in person one day to mark progress towards a world, yes, with more justice in it because of CIGA, and that's my hope. I want to begin by saying a disclaimer that I use when I speak of this case. Nothing I say should be construed as affirming or denying anything that is classified, protected under the military judge's orders, the subject of an invocation of national security, or restricted by any classification guidance I have reviewed. So, as you mentioned, I am the ACLU's director of the John Adams Project. That's the project was formed in April of 2008 to provide experts and lawyers who are skilled in capital defense to the capitally charged Guantanamo prisoners. It's named for John Adams, who was a president of the United States, but who, before he was president, represented British soldiers accused of a massacre during the Revolutionary War, and said that his defense of those prisoners was the greatest service he ever rendered his country. That hasn't been the reaction so far my government has given me, but we'll see. There are six capitally charged Guantanamo prisoners. One in a separate case on his own, Mr. Al-Nashiri, is charged with the USS Cole bombing in Sana'a Harbor in the year 2000. I won't talk very much about his case, but it's instructive that he's charged under the laws of war, crimes of war, which all of the cases on Guantanamo invoke, even though there's lots of language of Americans saying things like, Al-Qaeda started this war with the unprovoked attacks of 9/11, 2001, which is apparently sort of, invoking the war which magically started a year before in Sana'a Harbor from Mr. Al-Nashiri. The second session in this conference, I urge everyone to watch, talked about the chilling notions of pre-crime that are being invoked both in the United States and explicitly in Great Britain against Muslims. And I think that Mr. Al-Nashiri is charged with sort of pre-war prescience, as well as the kind of prescience it takes to charge Muslims with pre-crime. Needless to say, the notion of hostilities and when did war begin and what is the law of war has been very central to the litigation on Guantanamo. Mr. Al-Nashiri, attorney, several of his attorneys, 3 of his attorneys left the case in a very spectacular fashion after years because of the attacks on them and because of the attacks on the attorney-client relationship, which will form the bulk of my comments as the subject of, an examination of the tactics. So the chief tactic I'm going to take a look at is the tactic of trying to disrupt and destroy the relationship between lawyers and their clients in a death penalty case. There are 5 capital defendants in the 9/11 case, including Khalid Sheikh Mohammed, whom I represent, along with Mr. Sowards, whom you heard previously. Mr. Mohammed is Mr. al-Baluchi's uncle. And I'm also, of course, my colleague Jay Connell represents him. There were initially 6 men charged with 9/11, or supposed to be charged with 9/11. One, Mr. Al-Qahtani, was never brought into this case because the government, a very conservative government agent, said we can't do that because we tortured him. The difference was, we believe that his torture was by the military DOD and more was known about it at the time. But because certainly all the men in these cases were tortured. So there are 3 sort of historical features of US death penalty law and international law that are, and of United States history, really, that I think are, they're the view from 20,000 feet sometimes, but I think it's relevant to just briefly mention them because the title of this panel is Examining the Dangerous Tactics. And I think you don't understand how successful, outrageous, and the source of those tactics without taking a look at that. So one is the notion of the death penalty as it has been, as it manifests in US law, and why death penalty trials are uniquely susceptible to Islamophobic abuses, because they are about the person. The question of the death penalty in American law says, in the context of a convicted murderer, is this particular murderer worthy of a death sentence? So to believe in the death penalty as it is carried out and as it is ensconced in the law in the United States, you have to believe two things. You have to believe that some people, by virtue of what they have done and who they are, deserve to die. That they are the worst of the worst among convicted murderers. And secondly, you have to believe that United States law can be counted upon to fairly distinguish those people from the much larger group of convicted murderers. That makes Islamophobia particularly and uniquely relevant in the death penalty case. Secondly, in the United States, all law, criminal law particularly, death penalty law particularly, and these trials most emphatically have to be understood in the context of race. Our colleague of the Just Mercy fame, some of you may have seen it, was a fairly well-received movie, was about our colleague Brian Stevenson. He says that the worst thing about slavery was not the kidnapping, forced relocation, forced labor, and lifetime imprisonment that slavery entailed. The worst thing about slavery is the doctrine of white supremacy and the belief in inherent inferiority of people of color that sustained slavery. And you have only to look at the events of January 6th in our capital to know that that doctrine of white supremacy still exists and still affects American law. I'm sorry, I set a timer. Oh, there we go. And then thirdly, the so-called war on terror and the torture program of the US military intelligence services, which my colleagues have so eloquently talked about. Torture was key to understanding some features of Islam, as Gary mentioned. That is one of the consequences of these three interwoven strands. Going forward from the torture, from the awfulness of the Black sites, one of the persistent tortures that actually has a real significance in terms of ability to withstand trial, ability to cooperate with counsel, is solitary confinement. So while the worst of the Black site tortures were, not continued when the prisoners were moved to Guantanamo in September of 2006, solitary confinement was a feature for most of them of all of their imprisonment until some amendments were made quite, fairly recently because of the necessity of trial and hearings. So they're brought together in the courtroom, for example. I thought, I came across this quote recently. This is Archbishop Desmond Tutu of South Africa, the Nobel Peace Prize winner. And he says, "We are all wired neurologically to be caring for others and to be generous to one another. We shrivel when we are not able to interact. This is part of the reason why solitary confinement is such a horrendous punishment. We depend on the other in order for us to be fully who we are. This is the concept we have in South Africa of Ubuntu. It says a person is a person through other persons." And the significance for the tortured individuals on Guantanamo is that the healing of trauma requires community. So, and this is, very not disputed among experts, psychologists, and others who work with torture victims, that what is required to provide healing is safety, narrative, and community. And for Muslims particularly, the need to pray together, the need to be together, the need to seek in the Ummah the restoration of the sense of self that the Archbishop spoke about is so critical to healing, to understanding who you are, that to deprive a prisoner of that and then say we're going to have a trial that's all about who you are is particularly Islamophobic and cruel. The concept of white supremacy leads to the hierarchy of persons that is the core of any Islamophobic worldview. That some persons, by virtue of who they are just better, namely white persons. And it leads to, therefore, there is a hierarchy of the entitlement to rights, including the right to counsel and right to a fair trial. And so instead of rights inherent in personhood, in being, in the relationship between members of the Ummah, you have a language that devolves to deserving rights. Who deserves to get rights? And so Guantanamo was created to make a place where people didn't deserve full rights. That's why it existed. They wanted to put it off the US soil and out of sight, basically, to create a place where people were less deserving. And who do we put on it? We put a bunch of Muslim men because they are in themselves less deserving if you are a white supremacist, if you are living the traditional race discrimination that is at the core of this notion of law. As an aside, this language of a hierarchy of rights, also you hear it all the time talking about American prisoners, so ordinary prisoners. So it translated very well to Guantanamo with the extra kickers. And it's showing up now in some awkward places for the government, this sort of punitive notion of assessing, a scale of entitlement to rights. And it, as I say, it comes from decades of over-incarceration in the United States and based in race discrimination, but it's showing up now in the vaccine rollout. So we're talking about who deserves a vaccine. Do you deserve to get a vaccine if you're a smoker? Do you deserve to get a vaccine if you're a prisoner or you're obese? And that hierarchy of right, it doesn't work. That's not what religion teaches. It's not what we know to be true. And it certainly is not law, international law. It does not make a hierarchy of rights, but this is what happens. So when you have a hierarchy of rights based in race discrimination, based in Islamophobia, who deserves the right to a fair trial? Well, certainly not prisoners who don't deserve food or light or sleep or freedom from torture or place to toilet. But what about lawyers? Don't lawyers get rights? So when you finally give these guys lawyers, give these prisoners lawyers, what then do they get? And that's going to be the remainder of what I speak about. Looks to me like I have about 6 minutes. Is that right?
Yes, exactly.
Okay, great. So the problem of this trial is, as Mr. Connell and Mr. Sowards really discussed, the problem of this trial is that is a problem for the government. The government wants a trial that looks fair. They put it on Guantanamo. They made up this military commission's jurisdiction to be less than the law that prisoners are supposed to get in the United States or in military men get in the military courts. But they want it to look fair. And they've got a lot of language about that. The CIA in particular will not allow the prosecutors to reveal details of identities and witnesses and places and some of the details of the torture. So it's one of my colleagues, David Bruck, calls it America's secret show trial. The paradox is built in there. We've got to keep a bunch of stuff secret, but it has to look fair. You can't have both. one of the ways that they've maintained the secrecy, one of the tactics that is deeply rooted, as I've argued or outlined the argument, in Islamophobia, is by a consistent attack on lawyers, on counsel, on defense attorneys, and on the right of defense attorneys and counsel to have privileged communication, to have private, we call it the attorney-client privilege in American law. I want to say very quickly, this does not only exist in American law. So the Inter-African Court on Human and People's Rights reversed an Egyptian death sentence for a pretty public crime, the Giza pyramid attacks, in part because the Egyptian lawyers were not allowed to speak confidentially to their clients who were tortured. So these are the notion that if you are defending yourself against a death penalty in particular, you deserve a lawyer with whom you can talk privately. It's the first. I was a baby, criminal defense lawyer in the late 80s, a public defender. It's the very first thing you say to a client when you meet him or her. Nothing you say to me can be revealed. It's totally privileged. It's private. Don't have to worry about it. If you write to me, that's private. If I write to you, you can keep your legal materials. Guards can't search them. You can't. The court can't ask for them. Don't worry about a thing, right? You can't say that on Guantanamo. A little brief history of lawyers on Guantanamo. So remember, no lawyers in the black site. So when Mr. Mohammed was seized in 2003 in Pakistan and turned over to the Americans, he said, I want a lawyer. They said, no, everything's changed since 9/11, and they tortured him brutally. When he was moved to Guantanamo in September 2006, and shortly within a few months met with the ICRC, he said, can I get a lawyer? And they said, some people are getting lawyers on Guantanamo. And he asked for a lawyer again in January 2007. Neither he nor any of the other defendants were given lawyers until they decided to prosecute the capital case. So they were given lawyers in in the spring of 2008. The guards frequently told lawyers coming to Guantanamo in those early days to represent people, these prisoners won't speak to you. You're British, you're American. They won't talk to any British or Americans. They told women particularly, they're not going to accept any women lawyers. And they told Jewish lawyers, they'll never take a Jewish lawyer. Really sort of lovely story that I was just reminded of recently. My former colleague at the ACLU, Zachary Katz-Nelson, was an early habeas lawyer for some of the other prisoners. And he said, he told his client, Latif Nasser, very early on, I want you to understand, I'm a Jewish person. If that's a problem for you, I want to be, honest with you in the beginning. And Mr. Nasser said, no, that's a relief to me. I'm glad you're being honest. And honestly, you're a person of the book. You're a person of faith. I'm a person of faith. He said, these guards tell me they're Christians, but I don't think that could be true because of the way they treat us. So with the barriers that were established to attorney-client meetings, we nevertheless started to try to represent these clients. And the following are the sorts of things that the government then did to make the notion that everything he says privileged a lie. They seized all of his legal materials. They did it in 2011, 2014, 2015, 2019, with no warrant and no right from his cell. They placed listening devices in the rooms where we met our clients. They were disguised as smoke detectors. They require the lawyers to say what language we're going to use when we meet with the client. I can't think of any other reason except because they want listeners who speak that language too. They have intruded into our IT systems. So we've lost electronic files. They actually real-time monitored what defense lawyers were, what sites we were on, and they seized some 500,000 defense emails. The courtroom is created with a sound field that has microphones all over that can pick up conversations at counsel table itself. They've had a number of successful infiltration of defense teams where the FBI and other agencies have gone to defense team members and said, we want you to be a spy on the defense team for the government, with varying degrees of success. They've had FBI criminal investigations of at least 2, probably more, of the defense counsel, spanning 2 separate FBI investigations over a period of 5 years. And those investigations were criminal investigations of the lawyers for what they had done in the case. In other words, they weren't investigating them for their taxes or something like that. And they use lots of the tools available to them, like suspending our security clearances and so on. Mr. Nashri's, Al-Nashri's lawyers left because they said, not only do we feel we're being listened in on, we've discovered new information about being listened to, but we can't tell him that. There are other items that make us believe we are surveilled. All of these have created, a situation where a client is reasonably can reasonably say, look, either you're just one of them too, you're just a plant, from the CIA who told me I was never going to be free of them. Or you're a very nice person, but you can't do what you say you can do. You can't prevent the government from intruding into a relationship that you said they couldn't attack. So I'll stop there because I see I'm out of time, but I think that this tactic of attempting to try somebody for a capital case while separating them from the attorneys that they pay to do it is one of the main, it's rooted in Islamophobia. And
thank you, Denise. Thank you very much. Unfortunately, Frank Peter can't be with us, so that's why I've given everyone 2 or 3 extra minutes. And now we'll move on to the questions. I will share with you some of the questions that have been pouring in. And the first one kind of connects to what Denise was talking about, who is more deserving or less deserving. And this is a question to all the panelists. So the question is, what needs to be done for the American people, and particularly the media and Congress, to do something about the erosion of rights, civil and criminal? So like quite a large question to all of you. So maybe we could, if we could sort of start with Gary and then move along, be great. So unmute yourself, Gary.
So people actually encouraged me to mute myself, so that's, thank you very much. I was going to say, actually, I wanted to hear the other answers first because that is a big question.
Okay.
But
no,
just let me say, I think that the problem is that, as Denise was just finishing up with, is that the erosion of rights are, the phrase I was I don't know if I coined, but I was trying to use was talking about the capacity for indifference and the tolerance of outrage. If any of this were happening to, sort of white guy defendants charged with anything, any place, there would be a huge uproar. And I think that's what it's based in. And it's also based in the notion, and certainly the initial excesses and license that were given to the perpetrators of all of this was a result of the manipulation of this notion of catastrophic, impending doom that we have to do something about. So it's once people kind of confront what's underlying it, maybe there can be a return to according, really what we're asking for our clients are very, very, very modest minimal rights for criminal defendants. that that anyone's entitled to. So I think that's the first issue: the education of what is underlying this and what's at stake.
Thank you, James.
There were a lot of actors in the question of who might act. So I'm just going to focus on ordinary people, and which I include reporters, within that, and leave Congress out of it for a moment. But there are so many stories that are difficult to tell because they take place over a long time scale, right? Media is driven by something happened today, and thus it's a big story for the next 24 hours. And that's true on social media, what ordinary people do as well. Whereas really there has to be attention to a larger structural problems like the incredible, mind-boggling size of the military intelligence complex, the surveillance state that has grown out of the United States and Europe and some of Southwest Asia too. That like everybody's in on the business now. That sort of massive surveillance state, which makes a whole lot of other abuses possible. In the just super short term, I think that if there are journalists watching, for example, it is possible to travel to Guantanamo. It's not at this moment because of COVID, but soon it'll be possible to travel to Guantanamo again. And whereas people, the general reaction of people when they hear you work at Guantanamo is, my goodness, I thought that closed in 2008. What do you mean it's still open? What do you mean we're still holding Muslim men prisoners? What do you mean that people are still suffering the effects of torture and other cruel and inhuman degrading treatment? And I think taking a look at some of those problems in addition to the problems of the moment are something that we have to learn how to do as a larger society.
Thank you. Yeah. Denise?
I completely agree with what both of my colleagues have said, of course. I do think that the run up to the 20th anniversary is going to, there's going to be some very scary language about that reverts back to why it was okay to do this in the first place, and we were never attacked like this, and that has this story that we know not to be true. And Jay is so right about how our story is not the morning of September 11th. That's the prosecutor's story. It was a beautiful cloudless September day. These planes came full of Arabs. They hate us for our freedoms. A bunch of Muslims. They're crazy. Jihad. End of story. But why could anyone want to attack the United States? We're wonderful. The other opportunity for story, though, is to say, why is it that 20 years later, this trial we still don't have a trial date. We're in pretrial hearings, and there's a long answer to that, but the long answer has to, we have people who are skilled in narrative, and we need to use the people who can tell the narrative that can assist us in getting a real answer to that. I also would not start with Congress. I would start with the U.S. people. But and a danger is that, as Gary Sowards showed us, it requires this focus, the Islamophobic narrowing to get away with these tactics in the first place. But as Jay mentioned, the real danger also is that they're now migrating to the real world of criminal defense. So there's been the war on terror is now permitting surveillance of lawyers in other contexts. So, particularly in immigration, where again, of course, it's people of color primarily. The one thing I will say is that there is an opportunity, I think, for international, at least conversation. As you may know, the United States left the UN Human Rights Council under President Trump. This is what we need human rights for. And that President Biden and Vice President Harris's administration has very much said, we want to come back. And fortunately, there's kind of, you don't get to just say, hey, we're back, you know, you have to ask to be invited again. And that invitation is going to come with some questioning about American statements in the past during universal review of CAT, for example, the Convention Against Torture. The three areas that the United States, the State Department will have to answer about are general race discrimination and killing by white police of Black protesters and Black individuals, the death penalty, American retention of the death penalty, and Guantanamo. And the U.S. promise to close Guantanamo and to give prisoners rights is something that I think should be discussed among international states. So,
thank you. So many questions coming in. I'll just have to go one by one. So why, again, a general question, why do most judges go along with the government's narrative, even though it's been abundantly clear that they lie or hide the truth? So if we can go around the table again. By the way, can you see the questions on the chat? No, you can't. Okay, I've got them. I've got them. I've got them. Don't worry. Yes, Gary.
Why? That's what.
So why do most judges go along? Yeah.
No, here and my answer is that's what I would like to know.
Okay.
But one reason, just limited explanation, and then I'll let my colleagues answer much better than I will. As someone explained to us going into this, as Denny and, well, Jay has experience in national security cases. This was Denny and my first foray into this. We had done sort of run-of-the-mill, if you will, death penalty cases, but never had we wandered into the Alice in Wonderland, Kafkaesque George Orwell birthday party that is the use of classified information and sort of a super escalated, turbocharged version of the classification restrictions that's imposed in Guantanamo. And the short answer to part of this is someone who does this, a very, very good attorney by the name of Ed McMahon in Virginia, said, look, what's going to happen is every time the government wants something, they're going to ask to meet with the judge ex parte in camera. Which is a fancy way of saying they go in his back door or her back door of chambers and we don't know anything about it other than they say, by the way, we talked to the judge today or we're going to talk to the judge tomorrow. Sometimes we get that much information. But while they're in there, they're going to scare the daylights out of the judge. And they're going to tell him, if you do anything to help the defense in this way, it is going to be Armageddon. Okay. And not to strain to link this to kind of racist policies, but understand that one of the reasons that George Bush Sr. Was president following Ronald Reagan was the exploitation of a case called Willie Horton that was sort of like every white person's nightmare of a Black person who was on furlough from the liberal state of Massachusetts, where Michael Dukakis was governor, running against the senior Mr. Bush, and allowed this person to have one of thousands to have a furlough, and he committed some horrible, serious crimes. And what we in the criminal defense community say is we kind of mark that particular presidential campaign and Dukakis's loss on the basis of the Willie Horton case, to the reluctance of any judge or any prosecutor or any probation officer anywhere to sign a piece of paper that he or she envisions will come back to haunt them with adverse results. The safest thing to do is to always go along with the prosecution. And we also saw this play out in open court. And I used to say there was this one particular judge, we've been through so many of them, who would ask the prosecution for an answer to something. They would give him a ridiculous, almost non sequitur answer that had been, as they admitted, wordsmithed by the CIA. Our answer is that under no circumstances do we either admit or deny, blah, blah, blah. And the judge would say, wait a minute, my question was, and they would repeat the same answer. And he would ask them a third time, and they would do it, which in most civilian courts would get you remanded into custody. And the judge would say, okay, got it, as if they had said something different, or as if they had said something intelligible. So, I mean, it goes back to what I was saying before. It is the manipulation of the fear that gives us this high capacity for indifference and tolerance for outrage.
Thank you. James, do you want to contribute?
Sounds like there are a lot of questions, so I'm going to pass and let's get to more questions.
Okay, sure. Denise, did you want?
I'll just only add that, it's sort of a smaller version, but I think the, lawyers and litigants will understand this as well. You cannot set up a legal system from scratch to take on the biggest investigation in the history of the United States and a capital case and expect the wheels to stay on. The wheels will come off, and they have come off over and over and over again. And one of the ways they come off is that judges just don't, even sort of halfway decent, well-meaning judges just don't get where they are and don't know. So in every other court, I mean, I've practiced capital defense for many decades, three decades, unlike Gary's 4, but mostly in the states of the Deep South, and there's not a lot of fairness going around. But there is something of a culture. There's a little bit of a history. This is the way you do things, and it's been worked out. We don't have any of that. So every question is brand new. And in our case, the government never gives an inch. They're not reasonable about, like, well, let's at least give you a little bit of a fair playing field over here, because it doesn't matter that much. They fight on everything, big and little. And judges are scared, because in the back, when they come through the back door, what they're saying is, you're going to get us attacked again.
Right, so I'm going to combine two questions we have here. So have there been any improvements, or have things become worse in the last 20 years? And what are the legal organizations like ABA doing to stop the abuse of the legal system? So if any of you have got comments.
That's a good one for Jay.
Yeah, he passed last time, so he gets.
Yeah, maybe start with him.
So the general news on the national security front is quite poor in the United States, because what were emergency powers in 2001, 2002 have now become institutionalized as the new normal. And now assassination doesn't even make the news in the United States. The civilian deaths don't make the news. The surveillance is something that people say, well, I don't really have anything to hide, while they're having an affair and watching porn and, doing all sorts of things that they probably would not like displayed to their neighbors and coworkers. The most exciting news out of the United States, of course, is the renewed focus on the role of race in the criminal justice system, which, of course, focuses on extrajudicial killing of minorities, but has prompted a longer conversation about the death penalty, about mandatory minimum sentencing, about the structure of policing in a way that hopefully has not yet borne all the fruit that it's going to bear. We may see more progress out of that, but it's a conversation that, 25 years ago would have felt radical and impossible. And now it's a conversation which is going on at every level of American society. So it's a real hope. Islamophobia is one small piece of that. It's not the main focus by any means, but there is a much larger conversation which may yield policy changes. We'll see.
Do either of you want to add to that?
Yeah, I would just add, and maybe Jay can correct me if I'm wrong, because it's actually he's the impetus for this. But in terms of the actual situation at Guantanamo, it has also sort of worsened in a way, but in a way that also exposes the problems inherent in the system. In that, through Jay's good work, we are. When we were last there, we were embroiled in an actual evidentiary hearing on a suppression motion, or what we called a dry run of a suppression motion, to see whether it could actually yield evidence in a way that gave us a fair opportunity to litigate the issue. And what Jay has actually demonstrated is that the more we are efficient and effective at litigating the particular issue with the introduction of evidence uncovered about torture and the government's action behind the scenes, the more the government reacts to realize that they have left some escape hatches uncovered or some avenues unblocked. And so they were always in the process, or not always, but very frequently in the process of revising what they called their classification guidance, which was really a way to choke down access to information or to use information that had previously been obtained. I don't know if that's a fair characterization, Jay, but you can speak to that. But in that sense, we thought things were bad, but the government is realizing they weren't bad enough.
Okay. I'll move on to the next one. So another question is, would the trials be held differently if they were being held on US soil, and are there still any black holes or rendition used by government?
So I'll take that one.
Yep.
And Gary, would you mind muting yourself real quick?
Not at all.
Just a little feedback. The way that we left the issue at the end of the Trump administration is that the court with relevant jurisdiction, the DC Circuit Court, had ruled that no person who is at Guantanamo is protected by the Constitution of the United States, which is the equivalent of the Charter of Canada, or an organic document of any country that establishes the rights of people who are subjected to government action in that country. We're waiting to hear the Biden administration position on that. They could change that. They could take a different position in the cases which are making their way through, including a case at the Supreme Court. And so in that way, it would be very different if the case were held in the United States, because there would no longer be a question about whether people that the United States has captured and brought to US soil, or whatever Guantanamo is, then whether they have the rights of everyone else who is in that situation. And then the other question was, is rendition still used? And rendition is a large idea of extrajudicial transfer of people between countries. And rendition as a word is not necessarily mean to a CIA black site or anything like that. And the United States Supreme Court has ruled that rendition is legal, that in a famous case, they captured the DA sort of entrepreneurially went to Mexico and captured someone, brought them to the United States against their will and without the consent of the Mexican government. And the United States has a doctrine that says that it doesn't matter how you got your defendant to a court. Once they're there, that court still has jurisdiction, except in very, very limited circumstances. So yes, certainly rendition is still used by extrajudicial transfers, like capture people and bring them to some tribunal or non-tribunal, is still used by the United States and plenty of other countries too.
Anyone else want to take up that about the black holes, as it were? Okay. I'm going to move on to the next one. So what can foreign governments do if anything, to stop these abuses? Anyone?
I'll start by, I won't repeat what I said about governments who are interested in the U.S. readmission to the UN Human Rights Council, but on a larger sense, governments should be asking the United States to, for example, withdraw the executive order issued by President Trump and Secretary of State Pompeo against the International Criminal Court. The behind the scenes betting is that the reason that they have not has less to do with the ICC's investigation into the situation in Afghanistan and more to do with the investigation into the abuses against Palestinians by the Israelis. But whatever the reason, we should be, the new Secretary of State should not get a, after the handshake and gee, we're glad you're not Trump, there should be some kind of request to acknowledge. And broader, there is a robust and established human rights, panoply of procedural abilities. Jay Connell and his team have made wonderful use of the Inter-American Human Rights Commission and bringing Mr. al-Baluchi's case there. I urge states and people who can ask their government, please do this on behalf of Muslim prisoners, especially ask the United States to answer for its treatment of prisoners in Guantanamo. And ask them to close Guantanamo, compensate torture victims, And the other thing, of course, is that countries can accept prisoners. So if we're to close Guantanamo, there are 40 people or some percentage of that 40 people who have to find safe countries that will accept them and treat them right. And so ask your country to be one of those.
Mm.
And so Denny is right, but I'll add to that there are a number of small and large steps that other countries can take. For example, they can demand consular visits with their nationals in Guantanamo and other places, whether that's in a regular U.S. prison or not. They can ask for repatriation of their prisoners. They can offer facilities for rehabilitation, torture rehabilitation, and others, and other treatment that's needed. I mean, there are a number of countries that have very strong programs for refugees and others who've been subjected to torture. On a small scale, they can sponsor journalists to go to Guantanamo because it's kind of expensive for foreign journalists to travel there. They can ask for representatives from their own countries or from supranational organizations to be monitors at Guantanamo. France has sent someone to Guantanamo to monitor on one occasion. And, there's a lot of small things that countries can do at very little risk to themselves to make it be known that extraordinary judicial processes like those that are going on at Guantanamo will not go unseen by the international community.
Thank you. Another question, having been there for many years, what are the structural problems that you think must be addressed to fix most of these problems, and kindly distinguish the legal and the political fixes? The audience member asks, so if anyone would like to.
Gary's turn, I think.
Okay.
Well, actually, when you started with structural problems, I was going to say you could start with the housing situation, but that's a different issue. I think I guess my concern is the questioner kind of presupposes that we want to fix something to, if I'm misunderstanding, to get it running. Which would be great. But I think the real issue is a way to actually repatriate or even transfer. Jay mentioned repatriation. There's also the possibility of a number of countries have agreements and procedures by which prisoners can be returned to home countries where they can, if it satisfies them and satisfies the United States government, where they can actually serve out definite terms of imprisonment or punishment under better conditions and with access to family members and things of that nature. What our goal is looking at is a way to end these prosecutions, to shut down this sort of ersatz parallel universe court, which to almost any I think candid observer combines sort of the least good aspects of both civil law and military law, and again was purpose built to primarily obtain the conviction and the execution of Khalid Sheikh Mohammed. But then if they can get his co-defendants, that's fine too. But this was the debate in Congress. If you look at the statutory debate on Military Commissions Act and the successor legislation mentions Mr. Mohammed by name. It is designed to have him killed. And to the extent people have tried very, very hard to inject common rules of due process and fairness into this system, which would be addressing these sort of structural changes. That has been the focus. That has been part of the focus of the litigation. And as Denise said, the points at which the government will not budge and insist on not affording those rights, those freedoms, those fair processes. The other focus of the litigation has been on the torture that these individuals suffered, and again, the government's refusal to disclose or acknowledge all of the details. They want to give a very watered down, whitewash version, almost the Barack Obama shrug of "we tortured some folks," and then they want to move on. But understand that the structure, kind of a structural rehabilitation, which I don't think is worth the effort as much as the effort should be to end these prosecutions, also implicates a lot of other players and I think government sensitivity. One of when you mentioned earlier the involving international courts of justice and human rights without naming any particular place, for the reason that the government is so kind of paranoid and sensitive to the issue of their conduct being disclosed, the details of their conduct. We use the example, we have to talk in terms of the example of what if this torture happened on the moon? May we inquire of the lunar government who participated in these activities? Well, there have been instances where individuals with security clearances representing tortured clients have had a tangential role in promoting litigation in transnational courts, and for that reason have lost their security clearance under the theory that they are somehow confirming the involvement either in the United States or a lunar government in these torturous activities. So it's a very difficult undertaking or task to do, but I think at bottom, it's a game not worth the candle. What they should be doing is dropping these prosecutions and returning the people who don't have charges to their home countries.
Yeah, please.
So I'll take
Wait a minute, I'm muting Jay, hold on.
The political side of that question. There are three things that could be done like right off the bat on the political side. The first one and the smallest is there are 6 people at Guantanamo who are cleared by every U.S. intelligence agency for transfer to another country. But the Trump administration shut down the office which was responsible for negotiating those transfers and then monitoring their treatment afterward, which also means that we stopped tracking people who were left from Guantanamo, who were released from Guantanamo. And that's bad on numerous fronts. One, if they are mistreated, or 2, if they return to violent action against other countries. I mean, there's plenty of reasons why you would want to keep track of people who are released from Guantanamo. So that can be that's a matter of that's not even an executive order, right? That's just the Biden administration decides, hey, let's reopen the office. They still have furniture in there. Let's put some people in there too. Super easy. Moving up one level from that is that another easy, relatively easy political idea is to include the Afghan prisoners at Guantanamo in the ongoing peace negotiations in Afghanistan. You know, both the Trump and Biden administrations have expressed a commitment to ending the U.S. war in Afghanistan. And there have been ongoing peace talks which are fairly advanced, and repatriation of prisoners in peace talks is common, and prisoner exchange or some sort of resolution of prisoner issues is quite common in that sort of thing. Although, to the best of my knowledge, the United States has been unwilling to include repatriation of Afghans in the peace negotiations, which it should. And then the third is the biggest, but perhaps the most important, is that the legal authority in the United States for killing, assassination, and ultimately even torture were two resolutions passed by Congress in 2001 and 2002 called the Authorizations for Use of Military Force. There was one that was passed with regard to Afghanistan, Taliban, and Al-Qaeda, one which was passed with respect to Iraq. And those authorizations for use of military force are relied upon by the military-industrial complex to continue everything they do. In fact, the assassination of Soleimani last year was justified under the 2002 authorization for use of military force, which was set up to address Saddam Hussein, who of course now has been dead for many years after his execution. So there are a lot of political things that could be done domestically in the United States, some difficult, some easy, to change the infrastructure that we have built for the most dangerous tactics of the war on terror.
Right. We've got about 10 minutes left, and connected to what you've been saying, maybe this question should have come earlier, but the question is, what is the situation at Gitmo now, and what rights do they have? And added to that, can those people, if I guess, ever get out of Gitmo, or sort of, can they sue the US government for damages in any kind of way?
So I'll just take that.
Okay.
At least under law as it is right now on 30 March 2021, and it is dynamic, as I mentioned earlier, the current situation is that the one source of rights that we know for prisoners at Guantanamo Bay are set forth in a thing called the Military Commissions Act of 2009, which was passed by the Obama administration. That sets a kind of floor of rights. We know that the United States refuses to apply the Geneva Conventions to prisoners at Guantanamo, including most recently the provision of, which is one thing which is in the courts right now, the right to a mixed medical commission, that if a person is ill, either mentally or physically, normally under the Geneva Conventions, they would have the right to a mixed medical commission, part detaining power, the United States, part people selected by the ICRC to evaluate their medical condition and whether they should be repatriated or transferred to a third country. And we know that the United States just amended its policy on that to try to exclude Mohammed al-Qahtani, who Ms. LeBeouf mentioned earlier, from the application of the same rules that the United States applies in every other conflict. Suing the United States, there have been many attempts to sue either the United States or, as Mr. Sowards mentioned, private contractors who have been involved in abuses. Those have all failed, normally on some state secrets type basis, with one exception, which was when Ms. LeBeouf's organization, the ACLU, successfully sued Dr. Mitchell, who I mentioned earlier, and Dr. Jessen for their role in the abuse of 4 prisoners who were never brought to Guantanamo, but were tortured in other parts of the world.
I mean, I think you had something to say.
No, I was just going to actually that I'm happy that Jay went first as always. Just and one point, and that is to your question about and can they ever get out, presumably by other means, and that is one of the interesting factoids about at least the death penalty military commission's proceedings that we are spending so much time and money on, is that it really doesn't matter if they are found not guilty at the guilt phase of the trial. The capital trials are in two phases. One is whether the person is guilty or innocent. If he or she is found guilty, then you move on to a sentencing phase. And essentially, the government has signaled that even if a jury panel of military officers, which is what we will have at a trial, even if they find that Mr. Mohammed and his co-defendants in our case are not guilty, the government will not release them. So for that purpose, the trial is, I think, as Denise said, is one of more show than substance. So they cannot get out as a practical matter.
Okay, Denise, do you want to add something either to this question or further on to the other ones? Okay, I don't really want to, we still have got 7 minutes left. I don't want to launch into another question, but we have another one, so I'm going to throw it at you. So the question is, how the defendants pleaded guilty, and you are just litigating the punishment, or will you still go through the trial on 9/11?
So I'll start.
Okay.
It's a matter of record that the defendants tried to plead guilty in two different ways at two different times. So there were two military commissions. One was begun in 2008. It was under the Bush administration, the waning days of the Bush administration. It was a very rushed matter, very few resources available for the defense that weren't provided by my organization, the ACLU. And we had just really met the prisoners in there, and the lawyers were just beginning to, I didn't meet with any of the prisoners at that time. I was there in Guantanamo, but I was behind the glass. The way the courtroom is set up is that there's a gallery glass where people without security clearances sit. And there's a 40-second time delay so that if something was said inadvertently or deliberately that violated classification, you could stop the feed and the people behind the glass wouldn't hear it. It's led to some interesting moments in the proceedings. But the defendants sought to represent themselves in part because of the sort of barriers I alluded to in my remarks, that as one of my colleagues said, these were tortured men who had been in the custody of the United States for years and years, subjected to torture that they knew was a violation of international law, and they're sort of brought blinking into the light and said, "Here, want a lawyer? He's an American. He may be wearing a military uniform. Good." And many of them said, "Not good. I don't want to talk to this guy. I don't know what's going on here. It's the first time I've seen my brothers in 8 years, 6 years, whatever." So they attempted to plead guilty, and there was, without getting into the weeds, there was, it clearly was, I believe, a torture response in part, and in part the early conditions. They would have said, "We'll plead guilty. We don't want any of your process and your American lies. We will accept death. We know you want to." That got stopped short by the inadequacies and the miserable drafting of the military commission's law at the time. Years later, there was an effort, which is public now, to make what's called a plea bargain, to arrange a plea, at least on behalf of our client, with the government, which is the most common way for death penalty cases to be resolved in the United States. Most death penalty cases, by a very large percentage, do not go to trial. Capital case, they get resolved with a plea bargain where the government says, okay, we won't execute you, and you agree to plead and accept either a life sentence or some term of years. And it's a matter of record that those negotiations had not been completed, but they had begun and were proceeding. And the Trump administration actors, specifically Jeff Sessions, who was the Department of Justice head at the time, said, I don't want that. I don't want you making deals with guys on Guantanamo. And we believe illegally stopped it. But as Gary said, when the government tells you the only consequences of an acquittal is nothing, there's no consequence. I mean, you're locked up in Guantanamo now. If you get acquitted, you'll still be locked up on Guantanamo. So the only real question in this case is the death penalty.
Thank you. Right, I think we'll have to stop it there. I wonder if Fadi or any of the CIGA people will be taking on from here. I think we kind of have to introduce the next panel, something along those lines. Yes, there we are. And do we just leave the panel? How does it work? What do we do?
I want to watch the next panel, but I
use the next panel, and that's it. Thank you very much.
Okay, thank you. This has been very humbling, and thank you so much for your efforts. And I've learned so much, and I'm gonna make all my students watch this panel, inshallah. Thank you so very, very much. Take care.
Thank you all very much.
Thank you so much.
Thank you.